Welcome to the HC Commodities podcast, a podcast dedicated to the commodities sector and the people within it. I'm your host, Paul Chapman. This podcast is produced by HC Group, a global search firm dedicated to the commodities sector. Today we are talking compliance and enforcement in the commodities sector. Global regulators are narrowing their focus on the commodities sector, and billions of dollars are being paid in fines. The world has become both more transparent and more risky in the wake of deglobalization, sanctions, and the energy transition and its increased public scrutiny. The risks are enormous, both to companies and individuals, and as such, compliance is an ever more important topic. To discuss compliance, enforcement, and best practice is Gerben Schreurs, partner at the Forensic Risk Alliance, or FRA, an independent forensics firm that conducts investigations, monitorships, and compliance reviews, as well as Barry Vitou, partner at HFW, head of investigations, white collar and compliance at the global law firm. As always, you can really support the show by leaving us a positive review on the platform you're listening on. And as always, I hope you enjoy the episode. Gerben, Barry, welcome to the show.
Thank you.
So we're talking compliance and enforcement within the commodities trading sector, which is obviously a key topic and has become more prominent over the last few years. We're going to talk about who's driving the enforcement, what's behind it, and solutions and strategies to make sure companies and individuals are least exposed. But before we, get too far down the line, what is the backdrop to the increased scrutiny that the commodities sector has faced over the last few years? What's driving that, and what do we mean by that?
I think that for many, many years, the commodities sector has benefited from being relatively unknown. It's sort of upstream for most consumers. Others have sort of taken the limelight, global banks, and for example. But increasingly, the scale of those businesses and their importance to the global economy has sort of pushed them out of the wings and onto the main stage. And they have now become a bit of a focus. That's been assisted, I think, in part because there have been some quite large cases that have sort of sucked them in based on the evidence that's been revealed. And so I think, and the global perspective, I suppose, is also important in the sense that we are light years away today from where we were 20, 30 years ago when it comes to enforcement and compliance. And so the global perspective is there's just an increased focus on compliance and increased, and we'll talk about this a bit later, due diligence expectations, due diligence legislation, and obligations which are being imposed on companies. So I don't think there's any one particular reason why this has happened. There's an element of evolution about all of this, but the upshot of all of it is that commodity traders are today, more than they have ever been before, in the spotlight when it comes to public awareness, off the back of, for example, things like Ukraine and all of the sort of supply chain issues that we've seen in recent years. They're just basically front and center stage in the public eye in the way that they weren't many years ago.
Yeah, thanks, Barry. And there is that. So there's firstly that element of scale, right? There has been significant consolidation within the sector, and you get these behemoth trading houses that really are at the very crux of global supply chains. What is this a fair statement? I mean, being sat in the US, the CFTC has always had a strong enforcement arm, and has been very heavily involved in particularly US gas and power markets since inception. How much of this is a story about European regulatory and enforcement agencies taking up the mantle as well?
I think there's definitely an element of that, and Gerben will no doubt chip in this in a minute. But I think it's fair to say that the US has the moniker of the world's policeman for good reason. But it's also fair to say that European and other enforcement agencies have become increasingly active over the course of the last decade or more. And increasingly what we see is not just the US acting on any of these cases, but we see global investigations. Oftentimes the US is also involved, but more often than not now. And when I'm thinking about the commodity traders in terms of global resolutions, I can see that I think there's about 3 or 4 in the top 10 these days involving the US. So it's a case that enforcement and compliance of the sort that you've seen and are familiar with in the US has spread around the planet, and the US and Europe is definitely up there as a place where they have accepted some of the mantle and are working together with US enforcement agencies when it comes to enforcement. Gerben.
Yeah, no, I agree, Barry. And I think it's a clear trend that we've seen it in some other sectors where there was initial a push from the US to sort of police certain topics, if we use that word, and that more local regulators and prosecution officers would follow. See the same here, and some mind change in European countries. And I can speak for Switzerland specifically as well, where they used to not enforce extraterritorial, saying, if it's not taking place here, it's not an issue, and that position seems to change. Or at least their inquiries are going into the direction that even though your action doesn't take place outside Switzerland, they would like to inquire and understand for a Swiss-based headquarters which actions they have been responsible for, which is a trend break with past behavior from regulatory agencies.
Yeah, and I think if you are extremely cynical about it, and I might be, you've had a scenario where for many years the US was the lead agency, in many cases the sole agency in relation to enforcement, not just in relation to commodity companies, but more broadly, and undertook an investigation and fined and oversees a non-US company an awful lot of money in relation to some sort of regulatory infraction or failing on the part of that company. And I think there's an element to this of, why would a sovereign state allow another sovereign state to fine one of their own, for example, and bump up their tax revenues in circumstances where they're sort of sitting back and doing nothing, and perhaps the same sort of regulatory problems would be triggered in their jurisdiction as well. So when you look at some of the fines which have been meted out in relation to commodities companies and others, you are talking serious numbers, hundreds of millions, billions, whatever. And there's also, I think, for, again, non-US sovereign states, it looks very awkward to have a situation where the US is the world's global enforcer and you're passive. So I agree with Gerben, and increasingly the US sometimes argues that it takes up the mantle in circumstances where perhaps local compliance authorities don't do it. Well, I'm not sure that you necessarily want to have that reputation if you're a non-US sovereign state. So there's all sorts of reasons why they would be interested.
Yeah, follow the money.
And I think there is a factor of peer pressure amongst states, right? Especially if you look at in the sanctions domain, it feels like none of them wants to stay behind, which is a change from the way past, where certain economies would simply decline participating, and you see that it's now more standardized across the globe, also allowing all of them to be more enforceable.
Yeah. Okay, and then the other, I guess, the corollary to all of this is obviously as well that in a world that's increasingly digitized, increasingly transparent, money flows are far less likely to end up as cash transactions and so forth. It's a lot easier in some ways to identify issues. That's a broad systemic cross-industry trend. And secondly, I guess this is where I want to lean in, is a little bit that there is some uniqueness to the commodities sector that exposes it to potential issues around compliance and exposes it to enforcement agencies that are inherent in the nature of how commodity transactions work and the organizations, particularly the Swiss-based trading houses, operate. Barry, can you give us some sense of what is it that makes these organizations more at risk than typical corporations? And then, Gerben, maybe you can chime in.
Yeah, so I think there's a couple of points that sort of strike me immediately from the question. The first is that we are living in an increasingly connected world. And so contagion can spread pretty quickly. and there's a lot more cooperation around in terms of intra law enforcement than there ever used to be. So you have that aspect, which means that there's more risk. And I think that the very nature of commodity trading is such that it's inherently risky. If we look at sort of some of the hard commodities, for example, they're often in places where you wouldn't choose to. I'm sure people would love to be drilling oil, for example, in Switzerland, or any of the sort of Nordic companies which feature very high on the very various charts that there are for integrity and transparency, etc., etc. Sad fact is that's not where this stuff is, and so you end up in jurisdictions which are widely acknowledged and more than that, are pretty much proven to be very, very challenging jurisdictions. And that is the nature of a commodity trader. Typically you will be in a jurisdiction to obtain that commodity and trade that commodity, which is risky. And of course, with risk goes reward, but that risk is still there. So it's all about the amelioration of risk. I mean, to go to really picking up on the point, sort of linked to your first question. And if you look at, there's been a whole slew of recent enforcement activity in the US and elsewhere involving commodity traders. And if you look at where the roots of that were in terms of connectivity, you're looking at a South American jurisdiction with a corporation owned by a state that has been proven to, well, I think it's probably sparked one of the biggest corruption investigations, probably the longest running and still running sort of corruption investigations there's ever been. So you have a jurisdiction which is problematic from a compliance perspective, which spawns a corrupt enterprise. And then what happens is, and goes back to my point about connectivity, as they start chipping away at all that, they discover that there are intermediaries, and we can talk about those a bit later, and the risks that they pose to businesses. And guess what? They identify sort of a handful of intermediaries that have been used by certain actors in this matter. And then they just pull the thread, and they discover that it turns out that a lot of the commodity traders are using exactly the same corrupt intermediaries. And before you know it, you continue to pull the thread, and here you are. Suddenly, you've got a whole raft of different traders all being swept up into an investigation with the inevitable sort of compliance issues and then subsequent enforcement actions around the globe that we've seen. So very connected and just inherently risky in terms of the jurisdictions that they're trading in.
And maybe both can comment on this, but just to jump in, one of the challenges, so there's many there that expose the commodity sector in particular. As you say, primary is the sort of the resources being in jurisdictions where, business is more risky, and that's part of the outsized reward commodity traders receive. The other is, and this is kind of a growing trend, is obviously the reimposing of government intervention into the commodities sector in the wake of the volatility that we've seen. But much of these resources are government owned. And of course, that whereas you have a very transparent free market, where it's dealing with corporations, there's much less scope for taking rents. And of course, when you've got these commodities in the hands of national oil companies or state-owned actors, and you're talking about a market which is, there's no brand, there's no product. We're talking about, commodities where it's all based on, on cost plus. It just exposes you to these kind of forces when you are interacting with governments. And as you say, much of the issues that have arisen globally over the last 10 years are essentially tied to interactions with state-owned entities or governments themselves.
It comes down to a risk appetite, right? I think I don't disagree with any statements you made, or that you get close to state actors for some of these commodities. But I guess it's really a question, how do you deal with it? Do you follow their lead or stick to your own program, your own risk appetite in how far you want to go? And obviously it comes at a cost for your profit to be risk adverse. That's risk reward would look the other way. But it's more a long-term question on how you wish to operate, right? So are you in for a quick buck, or is this a long-term relationship you plan to develop? And that takes a different approach, I guess.
But that challenge there, and I completely agree, right? And obviously, as the risks are increasing with increased scrutiny, personal enforcement actions, and so forth, But you also at the moment face quite a fragmented commodities market in the wake of sanctions and so forth. And, you have, this is probably too long a conversation to get into, but you've also got now a suite of competitors out there who have a different frame of reference. And the other thing to drop in, and again, I recognise this is this could go on for a few hours, but you just the way incentives work within the commodity sector, within these trading houses themselves, where traders are in many cases rewarded directly on the P&L that they drive. You do set up therefore a different suite of incentives depending on where you sit in the hierarchy. And Gerben and I were talking about this before we started. You now also have these behemoth trading houses with significant equity value held at the top. There's a different suite of incentives, is what I'm saying, depending on where you are in these organisations, and that's where, and we'll come on to this, some of the solutions and so forth do need to be systemic to tackle that.
Yeah, I mean, I agree with all that. I mean, the point that you make about, I think that the commodity trading sector, the opacity around it, again, that's part one of that is one of the ingredients for risk. The fact that you may be dealing with, a state-owned company, whether it's by way of, obtaining a license or doing a deal or obtaining an oil block or whatever it might be to conduct your business, and you will be dealing with a foreign public official who probably isn't paid very much in respect to a transaction which is worth a lot of money in a jurisdiction which doesn't have much. And so all of those things and others all compound to create this risk profile. We'll talk about how to ameliorate that risk in a minute, but they're all definitely there. That's just part of the challenge that the commodity trading sector operates in. I think the point about the incentives is well made. So that's another factor which drives this. You've got all of those. You've got opportunity, if I would put it that way, in terms of the jurisdictions that you're operating in, and then you might have motive, which might be the incentive that you're talking about. So you have those two things, and so you are looking at, well, how best against a context where there is opportunity and motive to do we ameliorate or reduce the risk of something going wrong? There is, and part of that, I think, when it comes to enforcement, is in the deterrent. And so, and certainly for individuals, it's true that there may be all sorts of benefits and, cash, I suppose, to be blunt, that may be out there as driving motive. But, all of that can be taken away in circumstances. Your job can be, you can be fired overnight. You may be subject to retention of, I don't know, whether it's equity or bonuses. And you might find that you spend an awful lot of the money that you earned, fighting to try to keep your good name if you're impugned in this way. And for businesses, we could look at, I don't know whether we will touch on it, the scale of fines. It doesn't, I mean, they're sort of telephone number plus type fines, but that's only really the start of the story, because actually in order to get to that fine at the end of the day is a very lengthy process, which is obviously going to involve all sorts of professional advice over a period of many years. And even if you put to one side the cash cost that is involved in that side of the process, the management time that's involved in this process, and the drain on sort of intellectual resources while dealing with these problems is immense. So and it doesn't stop when you get fined and walk out the door, because then what happens in some cases is that there is some form of ongoing compliance obligation. At its extreme, that ongoing compliance obligation essentially means that you have a third party that doesn't really, you're paying them, but they're not working for you, that's reporting back to the enforcement authority about what they're finding in your business for a period of years after you think you've paid the fine, which again drives more costs, is more of a distraction. And for companies involved in that, sometimes they complain that that's the most painful part of the whole process. So the recommendation is always to try to prevent rather than to try to avoid that if you possibly
try and avoid that. Yeah. I want to really nail down that process, but Gerben, just from you, Obviously, most of these trading houses, the global trading houses, have been domiciled in Switzerland. How much of the story here is that the Swiss authorities and regulators are increasingly zooming in on this sector?
It's developing to be more focused on the sector, but I do feel that the Swissness to that extent is less important, and it's much more the sector plays a global role, and they happen to be domiciled in Switzerland. But the challenges and the risks that appear are not necessarily from Switzerland, although Switzerland is changing its mindset and becomes a bit more aware of the potential risks that reside in the sector. But I would say that the real problem that they can run into for global companies is really the extraterritorial reach from more active regulators at this stage, like the US. So I don't think it's a race between regulators and prosecutors to get there, but it's much more that the risk overall is rising, and that needs to be mitigated. And on the topics Barry just mentioned, what is the cost of an incident occurring, I think there's two more things that comes on top. One of is obviously sort of the reputational issues you would have, which then leads to the second problem that sometimes banks who are more strict on compliance, etc., will create a very hard time in doing your commodity trade finance part, because you'll raise a red flag in their onboarding of new clients. So on those credit lines, you suddenly deal with a different relationship on the finance side, which can also be expensive.
Yeah, and there is a note to make there that it seems like the banks are far more sensitive to issues in the commodities sector than necessarily, the technology sector and so forth that have received large fines, right? There is and commodity finance is the lifeblood of the trading sector, and therefore any kind of impact, even if it's a tick up in percentage or whatever it might be, has an outsized impact. Barry?
Yeah, well, I mean, I think you just have to, I touched on this to kick off with. I mean, the banking finance sector has seen eye-wateringly large penalties imposed against it for violations of, AML, for example. And they are extremely keen not to find themselves handing over more eye-watering sums. They've also had harsh compliance environments, essentially, that they now have them and they will have had them imposed upon them. And so they are extremely risk averse, is what it boils down to. And of course, the point that you make about commodity traders, well, they would be, yes, there's risk and reward there, but basically because of the challenging environments which people know that they operate in, which are at the top end of the risk spectrum, they are extremely cautious. And it may be one thing if you are, one of the extremely large commodity trading houses. But if you are not in that tier, and there's lots of them, as we know, then it can be extremely problematic if compliance issues are raised. And suddenly, depending on the nature of those compliance issues, so, for example, if there is, forget an investigation, if there is adverse media surrounding a company in relation to, let's say, Russian sanctions violations today, that would be a good example. You will find very quickly that the number of commercial counterparties that are prepared to deal with you will plummet. Many banks will simply not want to be involved with you. And that is as much a concern on their part that they might then be dragged into your problem and then find themselves on the receiving end of another eye-watering fine. And frankly, it's just not worth it for them. However much you're talking about is simply a fraction of what they potentially worry about in terms of how much they might have to fork out. And they therefore don't do it. They're not interested.
Yeah. And we've covered this on the podcast as well. You also had a long period of very low returns, and so many banks just got out of it. How does, just so we're all on the same page, and I know this is quite a basic question, but how does it work? What's the typical sort of sequence of events, when you get, some kind of enforcement action? What happens? Is it typically you get advance warning, or you just get a letter turns up on your doorstep saying, we've noticed this issue? Can you walk us through a little bit the process, especially when you engage lawyers and when you engage, FRA and so forth? Like, just what's that typical process before we talk about kind of some of the issues that have arisen and how to ameliorate them?
Yeah, well, I mean, it's probably something which goes to lawyers, I would say most of the time, that hits the lawyer's desk before it would hit the likes of Gerben's desk. But just to kick off right at the beginning, what are the catalysts for these problems? And the answer is they're many and varied. I mean, I again go back to my cynicism point. It's quite rare for this to result off the back of independent government sleuthing, I would say. Typically, there is some catalyst. And that catalyst, I would say, sometimes it can be a media expose. We've certainly seen media exposes of these sorts of things. So investigative journalists working away. There are lots of non-governmental agencies out there, Global Witness and the like, who are also out looking around for these sorts of things. We've seen the international networks of journalists which work together across borders with volunteer journalists, again, all doing this sort of thing. So the media is one way. Another way would be a whistleblower. Those whistleblowers can be internal or external. I often tell clients that, the whistleblower hotline, far from being, it's counterintuitively, it is not something which is a pain. It is something which is an opportunity for you, because if an internal whistleblower hotline is working properly, then you would hope that acts as the funnel for concerns from those employees or others that have access to it to report their concerns, so that you are able to then address those concerns and deal with them and remediate them and frankly nip them in the bud under your control. What I do see, and we still see it today, and there are some very well publicized cases of these, I won't sort of name and shame, but even today there are well-known cases where a whistleblower goes into a board of directors and says there's a problem. And, you would think in enlightened 2020s that would result in people taking that seriously and looking to resolve the problem. But oftentimes, or sometimes, that results in the individual, the whistleblower, being fired. And then you've created a big problem. You haven't dealt with the problem in the first place. You've got a cultural sort of ad that basically says we don't take these things seriously. And you've now got somebody on the loose who's looking to tell a story. And typically those whistleblowers, often, my experience, will go off to media organisations and law enforcement agencies because they want the problem sorted out. And then the next thing you know, going to your point about how a company might find out about it then, is they will have had advance warning because a whistleblower told them internally. They did nothing about it. In fact, they did the wrong thing as opposed to doing nothing about it. And the next thing they get is a subpoena or equivalent from another agency. Or worse, or perhaps they might get raided. In some jurisdictions are quite keen on raids, but in other jurisdictions they will do it by way of a subpoena or equivalent, basically saying to hand over all these documents, at which point someone like me receives that phone call from a client that says, look, we've just received this, what do we need to do? And then we guide them through the process, and part of that process will be retaining FRA, for example, who will have a role, in all manner of different things, from following the money and looking at internal accounts to try to work out what's been going on, to obtaining and hosting data so that documents and things like that can be reviewed, to working out what the quantum is if there looks like there's going to be a fine. I don't want to sort of steal Gerben's thunder because he can tell you about all of that, but basically there's a whole, it can come out through litigation. There was I think the Unol case, that's how there were rumblings of that for quite some time. There was litigation in London where allegations of bribery were made, et cetera, et cetera. There are so many different ways that it can emerge these days. And with the increased communication and the ease with which people can now publish. In the old days, it was the case that if you couldn't get a journalist interested in a story, if you couldn't get law enforcement interested in a story, then the story went nowhere. Well, now I think I can think of one quite famous case where it's sort of, if you traced it back to its roots, it was comments on maybe in a newspaper or a blog or something like that by a disgruntled former employee making various allegations that then got picked up and then, years later resulted in fines running to, I don't know, probably about $1 billion, I would have thought.
The energy and resources sector is experiencing unprecedented change. to help companies navigate this world and capture its opportunities. HC Group launched Enco Insights in 2023. Enco has rapidly become the leading global expert network dedicated to energy and resources. Enco Insights leverages HC Group's 20 years of connections and dedication to the sector to give clients the expertise they need to take decisions fast. Connect with Enco's experts for anything from a 1-hour insight call to a longer-term consulting project at encoinsights.com.
So you get subpoenaed, you get notified of an action, and I know this is very basic, but it typically, are these settled? Are they, fight and then post-settlement? What kind of things could be in a settlement order? Just to, and then Gerben, we can bring you in, I think, to talk about sort of the detail around that. But just Barry, just the what is the typical sort of decision point and pathways from that point of being subpoenaed?
To some degree, there's an adage, lawyers advise, clients decide. So in terms of which path a client wishes to take when faced with that scenario, then, they will make commercial decisions. But I mean, I suppose I would normally expect a client would receive and take very seriously a subpoena. So you would immediately start working towards complying with the subpoena on pain of criminal penalty to provide the relevant documents which have been sought. But at the same time as doing that, there would be, we work on a parallel investigation, because you want to know, you don't really want to be in a situation where law enforcement have reviewed everything and come up with their case theory, and you have no idea because you didn't bother to look at the stuff that you were sending over to them. So there'd be a parallel investigation into the sorts of issues and concerns which the subpoena was flagging. You'd be identifying those documents, you'd be sending them over, cooperating with that investigation, but you'd be doing your own thing as well, trying to get to the bottom of it, identifying relevant people, conducting interviews, and all the rest of it, to try to see what there was. So, law enforcement can get things wrong. I've worked on a number of things where allegations have been made where cases have ultimately gone away because it's not borne out. So, I mean, typically, as I say, you would you certainly cooperate, but we need to understand exactly, which way is up, what's actually happened, so that, those facts can be applied to the law. Clients obviously have the opportunity to defend their position if that's what they wish to do, or depending on the nature of the case, if the facts are not good, then perhaps they might seek to resolve that by way of resolution. I mean, the facts, when you look at the cases that happen, there are very few cases at the end of the day where corporations take a position which is, in other words, where they go to court and fight their corner. It's not unheard of. It's not unusual. But in many cases, if government persists, if the facts are adverse, they will seek to get some sort of resolution. The position, of course, is very different if you're an individual wrapped up in all of these investigations, where the choice between is not so much, the choice isn't how much is this going to cost me and when can I move on, which I suppose is ultimately always going to be the case for a company. The choice is, do I go to prison or not if they're indicted? And therefore, in most cases, there will be, it's much more frequent that an individual will fight their corner and defend their position than perhaps they say a company, on the statistics.
I want to come back to the personal risk side, but Gerben, I guess so much of this, and it also lends to this idea of why we've seen consolidation in commodity traders and why it is challenging being at smaller ones, comes down to how good your processes, documentation, the information flows, the money flows to be able to even adequately respond to that subpoena and even identify whether this is a more systemic issue. Can you give us some sense about where you come in and what you find and sort of the spectrum of kind of preparedness for this type of event?
Well, if it's the case we just described, we normally get in sort of when the lawyer was already informed and the letter is on the doorstep that action needs to be taken. There I would throw in the thought that I mostly call that phase getting an informed position, because most of the times you see that management and board members do not actually have an understanding of the day-to-day operations or are not personally actively involved. So for them as well, if that allocation comes in or that request for information, they want to get an informed position as soon as possible as they can, right? And that's where we can really add value by applying tools, technology, and processes to really get insight in, is there really some meat to the bone on this inquiry, or is it just something we don't understand? On that, it's mostly the corporation, but it all depends sort of on a few questions. How well is the compliance program designed, and the regulators and the DOJ, for example, will look at that in terms of determining a potential fine later as well. Is that well designed? Does it address the real business risks you have? And as well as, is the program being applied earnestly? They try to assess that. So is there a compliance program just for the form of it, or is it really lived by and taught to the wider company in that extent? And does it work in practice is also a question. And that latter part is more important in the phase which Barry just mentioned, that a few years after settlement, you might have a monitor or have to do self-reporting and show your improvements. But if it works in practice, in theory, you should be able, on the moment when the inquiry comes in, to really see the potential likelihood of that allegation being true or not, because you have it covered. You have your annual risk assessment. You understand that the risks are in a domain in which you really also see your own risk. Important is to say on those allegations, and I think you said a disgruntled employee that typed stuff on the internet, is that the world is changing a little bit there, that for the DOJ, for example, since March of this year, they're sort of incentivizing whistleblowers to step forward, right? And receiving a percentage of a potential
you get
fine.
A percentage, yeah.
And
that's been around for some time, hasn't it?
But that almost creates a new reality, and I'm speculating a little bit that for those real whistleblowers, I'm not disputing that. That's a reward for a risk they take, if you like. But it also makes it almost a risk that people can strategize to become a whistleblower on just something, right? Because it's worth it. So the dynamics is changing, but you have to take whistleblowers seriously. And I think what Barry just alluded to, that somebody coming up to a boardroom and saying, I think I disclosed the following, and ignoring him, is extremely risky nowadays, because they can simply turn around and work with authorities and be protected in that way, and then also potentially benefit from it financially.
And these are huge benefits, right? I mean, and I think I'm right. There was allegedly, there was a case in the US where in Power, where an individual informed on his own team and he was part of the actions and had an enormous reward for it as well. I mean, it really does up the ante in terms of potential exposures to this piece. Just, I guess, Gerben, from your side as well, like, obviously you have to have the right compliance program in place. That's both sort of the processes and so forth, but also the cultural approach to how you actually go about tackling this. How do you empower your compliance officers? How significant is that team within the organization? Have you seen in your time sort of a change in approach to that? I mean, we as HC Group obviously have done in terms of the prominence of compliance hiring, and maybe 10 years ago there were sort of skeleton teams, whereas now that seems like there's been a lot of investment going on there because of these increased risks that we're talking about. Can you just give us some sense, Gerben, of how you've seen perhaps that role change or heighten in importance, and how prepared organizations are today versus maybe a couple of years ago?
Yeah, I think it's and not just for the commodity sector. I think it's overall it's attracting more seniority, or it's more included in the primary business processes, where it used to be an administrative function on the side in the very old days, right? A tick box exercise that we comply with the following laws. And I think that is now much more part of the strategic thinking, but I would also be not too naive in saying it's now all done and dusted. There is still a lot of work to do to integrate it, because also the sheer drivers and incentives for a compliance professional or a trader are miles apart, right? They're not speaking the same language yet, and they're not actually most of the time being incentivized in the same way. So to melt that, there is still a lot of work to do, I think, as well as in terms of tone of the top, right? Where do companies want to go? what is the position in the market they want to take, that tone of the top, that governance they build around it. Is the compliance department independent enough that they can veto certain decisions, or will they never have that opportunity? All of those things make a difference in how seriously it's being perceived. But simple way, what you see the last few years is that a much more professional approach is taken, and that takes actually two type of activities. One would be more top down, and the other one would be more bottom up, where in the top down you would look at things like governance, tone from the top. You do a risk assessment where you do check your countries you deal with, industry specific risk. You make sure you have all of those documented, because having documented your decisions and your thought process, you'll also remain with a residue risk. But taking that top down documentation, group policies follow underneath that. You have whistleblowing policy, your regulatory settlements. How did you follow up? Having all of those things top down sort of structured and assessed and frequently updated helps you. And then bottom up, you would do much more analysis of what is happening within your company. And I think Barry alluded to, you can do a cash flow analysis. What are financial arrangements we have? How many third parties do we have in our books? The due diligence part, the provenance of excess assets and rights, the substantive testing. How much real testing do you do, or do you just send a questionnaire? All of these types of questions. The existing controls, do a frequent review of your controls. Is it all in place? Should we make an adjustment? Did the business model sale change? Is there a new distribution method, a new sales method in a company? Should we adjust? That whole concept, I can talk about it for days, right? But if we summarize those things, I think that is taking more seriously, but it's always important to have it properly documented, not just talk about it, but document. And even if you have some red flag signals, take action or document why you choose not to take action. Because in hindsight, once that letter arrives and it's a peak season on disclosing information, it will help if you have it ready, and the external parties, regulators and DOJ can follow your thought process, that it was done in good faith. That will help you to sort of be in a more nicer position negotiating with them than if you have it all undocumented.
Yeah, and that is significant, right? If they can see honest efforts were made and the right structures and processes were in place, they can see the documented thought process on any given issue. And it's worth saying that while some actions are clearly illegal, the nature of, say, the CFTC in particular, for example, is, there is a guidelines and intent issue there, and some particular market actions might be entirely new and untested. Some, there's not necessarily a strict codes in some of these things. It's more what was your intent when it comes to things like market manipulation, which can cause a grey area here. But to your point, having those decisions clearly mapped, the processes in place, if issues do arise, you're in a substantially better place in terms of enforcement, in terms of fines, in terms of potential future monitorship than you are if you don't, right? I mean, is that a fair statement?
Yeah, and that's absolutely fair. And I think it's also to protect yourself as a company, because how do you vouch if you have hundreds of employees for all of their behavior, right? You cannot. It would not be an ideal world. It would be nice, but it's not how it works. So as long as you have taken serious effort, have it documented, and can explain how you try to stay in the green with your business operations, I think it's for the company excusable if things go wrong. But I'll refer to Barry again, who's much more legal than I am. But it's excusable again, and that you made all the best efforts you could, and therefore you should not be punished if some employees individually have made different decisions than in line with your company philosophy.
Yeah, I mean, I think that, every company is either a village, a town, or a city, right? And the reality is every village, town, or city is going to have some bad actors. That's just a fact. And so I think my expectation is things will go wrong. Somebody will cross the line. They will do the wrong thing. They'll get something wrong. They'll make an honest mistake. They'll find themselves in a bad situation. But you want to have an environment where the person who finds himself in a bad situation, phones up compliance and we can get him out of the bad situation. So that's, to stop it, fix it to the territory. If it turns out that a lot of bad actors went off and did a lot of bad things, didn't tell anybody about it, which does happen, then, the reality is companies at the end of the day, they are just vessels for a bunch of people doing things, right? And so they're not inherently bad themselves. There's a culture point that we can talk about, but they rely, it's these things, culture, compliance programs, etc., which are going to help you if it turns out somebody did a bad thing, it was really bad, and you're going to be able to say, well, we undertook good faith efforts to prevent this sort of behaviour. Here are all the things that we did. I had mentioned at least twice, but basically, if you had all of that, but you didn't document it, as far as anybody is concerned, you didn't do it because you can't evidence it. So I always say sort of three most important things about compliance are document, document, document. But that's going to help you a lot. And if you're me and you're the lawyer, and we talk about negotiation, but it's important to be able to know where the boundaries are, and if as they sometimes do, law enforcement engage in a bit of overreach, that you're able to push them back. If I've got a really solid, and I have been in this situation in the past, and I'm pleased to say the result of, for a very large company, the result of the involvement resulted in no action being taken. But in that particular example, I was very, very confident that we had, in that kind of client's example, one of the best compliance programs that would have been existing at the relevant time. And there are good reasons why that might be the case. Once bitten, twice shy might be the answer. But the point was, I was absolutely solid that it was really, really good. And so when people came knocking on the door and saying, well, we think this happened, we think that happened, I was ready to deploy. Look, this is what we've got. We couldn't have done any more. And so that's really helpful from a company's perspective. Some of these cases, just you can navigate and end up with no further action being taken, or, a declination, or, worst case scenario, the least worst outcome possible with a fine or a penalty or whatever you want to call it, that's sort of not as bad as it could have been. I mean, there's a whole spectrum of outcomes here, ranging from absolutely nothing happening. And the best end of that spectrum is going to be if you've actually got a decent compliance program and, you've got something to say about it. I take your point about some of this stuff might be new, et cetera, and therefore there's grey zones and there's arguments to be made there. I mean, some of the cases that you do see and some of the resolutions that you do see, it is unfortunately the case that you're not in a sort of, slightly grey zone as to whether this was okay or not. There is evidence of extremely poor misconduct, bad misconduct. And so I think if you're a company, and I've advised various companies on the compliance programs and how you help with culture and all the rest of it, work with FRA and some of them, that's really, really important in making sure, well, one, that you can prevent, at the very least, reduce the risk of something going awry, minimize that risk. And two, at the back end, well, if things do go wrong, and they can and will go wrong, because at the end of the day, we're talking about humans are going to be somewhere in the mix, then, well, if I end up on the receiving end of a subpoena, if that unfortunate day happens, I've got a lot to say about that. And I feel like I did the best that I could. So there's a whole load of stuff in there, which from a corporate perspective is good.
Well, and a good compliance officer is worth their weight in gold, right? And actually are relatively scarce and in demand. And I guess HC Group has linked up with both of you, unbeknownst to each side, in the past, where we have, off the back of events, built compliance teams worthy of the potential risks out there. Just one final piece, just so I understand it, we understand it. When does this go from being a company issue to a personal issue? Because we've all seen recent events where individuals, senior leaders within trading houses have been named individually and face great personal risk, including jail time as a result of actions whilst at the company. How does that sort of corporate veil get pierced in that sense, and personal liability turns up? Is that is that where there starts to become a bit of a conflict between the company and an employee about where they want to assign blame? Just so I understand that.
Well, I guess, and this is a truism for both companies and individuals, it's all about the evidence at the end of the day. That's really what it boils down to. And so I wouldn't really see it so much as piercing the corporate veil, I would sort of put it another way, which is sort of a company only does things by virtue of those sort of people that can do things on their behalf at some level. And so what happened in practical terms, what does that mean? Well, that means that when the subpoena comes in, it'll be asking for a whole bunch of documents and information. Those documents and information will include lots of materials involving communications between, different people on behalf of the entity in relation to the sorts of transactions and deals and activities, conduct that they've been involved in as part of, in the context of their work for the business. And if some of those communications or that some of that information turns up evidence which rises to a sufficient level that a prosecutor thinks that they can have a successful prosecution, so that's less than the beyond reasonable doubt test, but more, it has to typically cross over the line that they think there's more than a 50% chance that they'll be able to, make a case, and potentially a jury might, without reasonable doubt basis, convict, which is a much higher burden for conviction. Then the prosecutor will apply their prosecutorial tests, and they may bring a prosecution. So typically, there will be evidence which rises to a level that the prosecutor thinks they can get their conviction, and therefore they then go after an individual in relation to a trial. I mean, another sort of practical example might be, and this is all part of the evidence building, and there's plenty of examples of this. They will look to flip people. So if you find somebody who was an insider, who was sort of the pivotal to the whole thing, they will say, we got you. Look at all the stack of evidence we have against you. Now tell us everything, and implicate people. And there's lots of examples of that as well. But yeah, it's all about what the evidence is. And of course, the people will disagree about whether that evidence is good enough. And so certainly from a lawyer's perspective, if that's the case, if you are faced with, if you're an employee, how this is all going to pan out, those documents are going to get looked at. Probably someone's going to come in and interview you if you're sort of in the dramatis personae, so to speak, of what was going on. And then they'll sort of ask you about what you were doing. They'll look at the documents and see whether there's any inconsistencies. They might interview you again. If the documents count for a whole lot, so if those documents are bad from an evidential perspective, the chances are that they will have been the subject of the subpoena. They'll be on the law enforcement side, a company seeking to cooperate, if that's the posture the company is taking with a law enforcement agency, may be extremely cooperative in telling the business, the law enforcement agents, about the misconduct of the employee and how really it was nothing to do with them. It was all down to the employee, and they had this great compliance program, and he was acting as a lone ranger off reservation when all this was going on. And so, the next thing you know, you're being interviewed by law enforcement wherever about all of this. And then that criminal process starts. And along the way, you would receive some advice around that. You'd receive some advice around how to interact with the internal corporate investigation, which is ongoing, there'll be complexities in there. There'll be advice around how to interact and deal with law enforcement interviews, if that's where you are. And if you think they've got it completely wrong, there will be, for example, and I've certainly used this with success in the past, the opportunity to make representations to law enforcement about why they shouldn't exercise their discretion to bring a prosecution. And sometimes that, and I've had this, results in no further action being taken. I mean, the worst case scenario, in the same way that when I'm representing corporates, and I do a lot of that, the worst case scenario is to find yourself in court at the end of the day. I mean, my job, which I, reasonably successful at, is to make sure that clients don't see the light of day in court at the end of the day, whether they be corporates or individuals, whether that be by way of no further action being taken because of however we've got there, or a declination, or some sort of financial resolution along the lines I've said. And if you're an individual, convincing either that there's not insufficient evidence and therefore a charge shouldn't be brought, or that there's no public, and if there is, there are various public interest reasons why no charge should be brought. It's the very end of that process, and this is a process which can take years, frequently does, because these cases are complicated. There's lots of evidence. It's typically cross-border and international, and that raised its own difficulties for both law enforcement and companies. But the very end of that process will be, and hopefully will not happen to individuals, but it would be a trial.
I hear you talk, Barry, and I think one thing, wouldn't it be easier to prevent this? Because it's so much, if you like, negative energy, and is it the company, is it the individual, etc. No, but that's what you see, that most of the times it then gets very complicated and it's sucking a lot of energy, positive energy from life, right? If you're in these proceedings, etc. So that makes a good argument for try to prevent and have clarity and transparency upfront as much as possible.
Yeah, the emotional toll, right? The emotional toll, and Gerben, you and I chatted about this, on leaders, on individuals. There's a financial toll, the emotional toll. Obviously, for individuals, this is and can be the end of careers. I mean, frankly, the backdrop to this as well, and sort of wrapping up in some senses, increased scrutiny, but also increased transparency pathways. You go back 30 years ago and most things were decided over the phone. There wasn't the paper trails, the text messages, the emails, all these pieces as well. And even if you're completely innocent, the amount of disruption and cost it can take to provide the discovery is extraordinary, right? I mean, and for individuals, this is where sort of that risk reward balance has really started to flip, is just tremendous.
Yeah, no, I mean, we just live in we live in a completely different world to where we were 30 years ago. And, I mean, even, in recent weeks, the world, the evolution continues. We've now got an EU corporate due diligence directive, effectively, right? So that increasingly businesses are being forced to conduct some sort of due diligence. Not conducting due diligence is no answer, because turning a blind eye basically fixes you with a notice you don't have because you didn't look in the first place. So that's a bad outcome. Of course, going back to my sort of villages, towns and cities analogy, there will always be sort of career professional criminals out there doing bad things at the end of the day. You're never going to overcome that. That's just human nature. And so the compliance program, if you're a corporation, is the way of trying to deal with that. The environment is that, we've had, if you looked at FCPA, for example, which was a late 70s statute, not much happened with that until relatively recently. And I use the word relatively there in terms of what's been going on. If you look at corruption investigations, non-US corruption investigations, again, it's a relatively recent historical phenomenon. You would get to relatively recent times. Actually, not relatively recently. You can put a date stamp on it. But largely before the implementation of the UK Bribery Act back in 2011, the Act being enacted in 2010, there wasn't much going on here. I think there were a couple of sort of initial forays, not many. And I can remember back in 2011, there were a lot of companies who were for the first time in the UK implementing an anti-bribery program. Fast forward to 2024, most companies have got them. So it's just things have moved on. And I think, if you're certainly, I've always thought this, that if you're an individual, again, putting to one side, most people, most white collar workers they're not career criminals. That's not how they start out, right? And the risk and reward, I mean, the risks are just completely alien to a white collar worker. And certainly, whenever I've represented individuals in those circumstances, it's extremely pressurizing. In fact, I often think that the greatest punishment they receive is actually the duration of any investigation, because it's not actually, people always look to the final resolution and what happened and the big fine. But you know what? It isn't about that. It's about the fact that the whistleblower thing comes in, or the subpoena is received. Within a few months or a few weeks, the evidence is turned up. It might be bad evidence. An interview is undertaken. The individual can be suspended. I've represented companies where individuals have been suspended for 2 years, because the prosecutor said, I don't want you interviewing those people, otherwise you won't be cooperating. If you're an individual who's suspended from a business for 2 years, that I can tell you, because I've witnessed it, what happens, how they feel and how they react. It has serious psychological problems. On top of all of that, no one will talk to them. Their colleagues won't talk to them. They've got this shadow of criminal prosecution hanging over them. They can't get another job. They've got very limited social interaction, or their colleagues won't talk to them anymore. It's an absolute nightmare. And then, if they're lucky at the end of all of that and the suspension is lifted and they're free and clear, that's great. But what if then what kicks off is after 2 or 3 years, finally, the authorities get round to some sort of charging decision and start to commence a criminal process? Well, then you're looking at years and years and years, extraordinarily expensive, even if you're bankrolled by a company or an insurance policy. The reality is that in the old days, insurance policies didn't used to claw back. They just regard it as sunk cash. These days, they look to claw back. So you end up in a scenario where there are serious psychological impacts if you end up in the crosshairs of one of these investigations. It's extremely expensive, extremely stressful, with the spectre, worst case scenario, at the end of the day, of going to jail, which is an alien concept to white-collar workers, because that's not what they signed up for in the first place. So it's just, again, to pick up riff off of what Gerben just said, listening, as I say this, and as I listen to what we've just been talking about for the last hour, prevention is definitely better than cure. And that's what, we try to help companies do, with an advisor around compliance, advise on the laws. There's, the corporate, the due diligence directive, recent stuff, there's new law coming into the UK about fraud, all of that stuff to prevent these problems. Because you really, you can look at it and say, well, there's a fraction of turnover. This is nothing. But the truth is the human cost is much, much, you can't really put a price on it.
Yeah. And actually, well said. And, everyone's been warned. And I've seen this as well with people who've been caught up in these investigations and, frankly become unemployable, right? And the impact and toll that has on them.
Yeah.
The other, just, final sort of comment looking toward the future as well is we're seeing far more corporations return to marketing and trading, right? So producers, oil majors, and all of those organizations bring typically much higher levels of expectations around compliance and risk taking and so forth. And companies themselves are going to start finding themselves excluded from some of these huge opportunities as new markets develop. If they come with these reputations, right? You'd much rather deal with an oil major or whatever it is, who at least prima facie would seem to have much higher compliance expectations and programs and so forth. So there's also the exclusion. It starts to become exclusionary and existential for some of these organizations, I imagine, down the line.
No, I think we can turn it around, right? Where you can say that if you do it well and you do it smart, so it's not just about the size of your compliance department, but how do you introduce it? How do you tag them along in your business processes? And can you make it a competitive advantage that you have that stuff under control, which I think we alluded to earlier, the trade financing part, but that's also, if you want, for production plans, etc., stuff financed. In working with certain governments who are demanding a certain level of transparency, and you can leverage it as a added benefit and really a competitive advantage. I haven't seen that too much yet in this sector, but definitely in other sectors where if you have that compliance and ethics and culture stuff under control, you can leverage it as a added value. And I think time would be smart to do it here. And the way I look at it is also, you saw on banking globally that they sort of got fined and then had to catch up. And there was little control over the narrative, if you like. It was top-down driven. I would say take a more proactive approach and try to remain in charge of the narrative as a sector, and do not wait until the next incident and some form of regulation is again implemented and you have to follow. You can actually take the lead on this.
I'll chip in. I'm just picking up on what you just said, but we've spoken a lot on this podcast about enforcement, but actually probably the far higher likelihood of commercial risk for a business for what should we call it, a regulatory infraction, is exactly what you say, namely commercial consequences, right? Whether they are not winning the deal, or as we've spoken about earlier, if you end up in a scenario, which is hardly likely, it seems to me, where an increasing likelihood, whether it be by way of whistleblower or there's a media issue or there's adverse media when everybody does their KYC on you as a result of AML or sanctions checks, which everybody's doing these days, you simply will find, represented lots of companies with these sorts of issues. M&A transactions, frequently, lots of people sniff around on an M&A deal. They're very interested because they look at the business, they think it's really exciting. They cannot get themselves over the hump that there is this compliance problem out there, right? Banks won't, as I think you highlighted, won't finance. Private equity investors looking to invest in the business. The big problem that these sorts of issues give rise to is uncertainty. And we all know how much businesses don't like uncertainty. And when you don't know the scale of the problem and nobody knows what the fine might be, then it ends up with people pausing commercial activity. And so that's why you often see, these investigations often go on for years and years. And if it's a public company, when they're resolved and people have certainty over the ticket price of what this is all going to cost, suddenly you see that there's a flurry of commercial activity. M&A deals happen, people swoop back in again, start transacting. But it's that uncertainty out there and the risk of it that really drives people to say, do you know what? I've got an opportunity cost to this. I've got other deals to do, and this is just too hard, too uncertain, so I'm not going to do it.
Yeah.
That's really the big risk.
Well, there's also one more I'll add to wrap up, a bit more of a pernicious issue, which is talent, right? You automatically, when you're facing these kind of issues as reputational issues, start to lose high-end performers who may otherwise have joined your business because they don't want to face the reputational risk, or they don't want to face the compliance risk, being in an organization that doesn't have a strong compliance program and policy and ethos. So actually over time as well, and commodity trading at its purest is really about the talent that you've got in the room to be able to compete. And if you're not able to access the best because you don't have the right reputation, that itself over time can be existential as well. And, we have seen that. There are stories and narratives around trading houses that no longer exist today, but could have been one of the behemoths today, but 10, 15 years ago had an issue and lost the key people because they just didn't want to be exposed to that for whatever reason. So anyway, well, we've certainly run over time, but it was well worth it. Gerben, Barry, it was a real pleasure to have you both on, and I think an important discussion, and probably one that deserves a part 2 on kind of a bit more about the future and some of the changes that are afoot. But we'll have to leave it there for now.
Thank you, Paul. My pleasure.
Thank you.
Thank you for listening. To find out more about HC Group, our global offices, and our expertise in search within the commodities sector, please visit www.hcgroup.global.